Hello. Well, here we are for the second part of the portion on North Carolina state law in connection with concealed carry handgun. We got as far as what to do if approached by a law enforcement officer, and hopefully people have digested that. The next lesson, the next portion of it, is on escalation of force. Escalation of force is merely the increase in the level of force based on that force which is being used against you. Force must be proportionate to the level of force used against you. For instance, if you are verbally assaulted, you cannot use deadly force to settle the argument. If we were to look at the various levels of force, the escalation would be something like this. And this takes me back a little to my time working at the streets of South Point as small security, because these concepts are very familiar to people in law enforcement and public safety. Maybe a little less so to civilians, although I think most people understand at some level of consciousness that what you do has to be proportionate to what's being done against you. So, first element, number one, physical presence. That's just being there. Number two is verbal. That's saying something. Then soft hands, and soft hands to my mind would be putting your arm on someone's shoulder or touching them or just gently nudging them, sort of, come on now sir, you know you got to leave them all, whatever the situation is, or you know this is my business and you shouldn't be in here, I got to ask you to leave. Just really you're getting their attention in a physical way. Number four, hard hands. Well, that to my mind is more getting them by the arm and pulling them towards the door, or getting them by the scruff of the neck, or maybe there's more than one of you. You get an arm each and you frog march them to get them to leave the premises. So that would be hard hands. Next step up is chemical. So that's mace or pepper spray, OC as it's known. And if that's not getting the job done, the next level up is impact weapons like a stick or a club. Now typically this isn't going to be so much in a civilian context, but if you're in your own house, someone is physically giving you a hard time, you might pick up a baseball bat or some other convenient instrument and make it clear to them it's time for them to get off your property. And that's the one below deadly force. So a stick or a club, pepper spray, hard hands, soft hands, verbal and physical presence should be exhausted before you get to the level of deadly force. Of course, depending on the situation, things could escalate very fast and you could miss out a few steps. But escalation of force as the law understands it. And back to the script, the increase in force does not need to follow these various levels. The level that is used against you and the imminent threat imposed against you will determine the lawful reaction to that situation. So if someone's getting in your face, shouting at you, and you pull out a can of mace and spray them in the face, that might be appropriate if you think they're very close to using physical violence against you. So all these things are judgment calls, and at the end of the day, on any judgment call, you're going to have to answer for it in a courtroom 2 years down the road with people who weren't there, and that's the yardstick that police officers have to think of. And if you can think in those terms, you can perhaps save yourself a lot of trouble. Next topic is prohibited carry areas. There are a number of areas where the carrying of a concealed handgun is prohibited either by state or federal law, regardless of the issuance of a concealed carry handgun permit. In other words, a concealed handgun permit does not allow a permittee to carry a weapon in these prohibited areas. A. Any educational property, public or private, of any kind. North Carolina General Statute 14-269.2. This prohibition applies in or on any school building or bus, school campus, grounds, recreational area, athletic field, or other property owned, used, or operated by any Board of Education or School Board of Trustees or directors for the administration of any school. A person with a concealed carry handgun permit may possess a handgun in a locked compartment or container within the vehicle, within the person's locked vehicle, or in a locked compartment securely affixed to the person's vehicle. Just to clarify that, if you're going to a school to meet the principal, or because your child's in trouble, or for whatever reason, and you have a lockable glove box in your car, you can leave your concealed carry gun locked in the glove box within the car, lock your car, and go about your business. If you're driving a truck and you have a toolbox on the back and you have your weapon locked in the toolbox, securely fixed to the vehicle, that also is acceptable. What's not acceptable would be to have the gun in a container loose in the bed of the truck, or just have the gun lying loose inside the car without being in a locked compartment. So I hope that's clear. The permittee may, backtrack a little. The person may unlock the vehicle to enter or exit the vehicle, provided the handgun remains in the closed compartment at all times and the vehicle is locked immediately following the entrance or exit. So you're allowed to get in and out of your car, but the handgun should be locked away inside the car. The permittee may also possess the handgun on their person as long as the permittee remains in the locked vehicle and only unlocks it to allow the entrance or exit of another person. So if you've got your gun in your waistband, shoulder holster, whichever your preferred means of carry is, and you're dropping your kids off at school or picking them up, that's fine. Just don't, according to North Carolina law, don't get out of the car with your handgun and enter the school premises. So these are sort of common sense provisions. Note, it is a defence to prosecution if the handgun were removed from the vehicle in response to a threatening situation in which deadly force was justified. Private educational facilities may still prohibit the possession and carrying of a firearm on school grounds in accordance with North Carolina General Statute 14-415.11 (C) 8. So, schools effectively are supposed to be gun-free zones, but you're allowed to have a gun in your car, or you're allowed to have it on you when you're dropping the kids off or picking them up. Moving on, B, certain state property and courthouses. It is also unlawful under state law for any person to possess or carry a weapon not used for instructional or officially sanctioned ceremonial purposes in the State Capitol Building, Executive Mansion, Western Residence of the Governor, or on the grounds of these buildings, including any building used to house any court of the General Court of Justice. Note, concealed carry handguns may be carried at state-owned rest areas, rest stops along highways, and state-owned hunting and fishing reservations with a valid permit. So, you pull in to the rest area to go to the restroom, you have your gun on you, that's fine, you're allowed to do that. But the Governor's Mansion, the State House, the courts, no, you are not allowed. Most of those places are going to have fairly prominent security and probably are going to have signs to remind you in any event. Note, any person who has a concealed handgun permit may carry a concealed carry handgun on the grounds or waters of a park within the state park system as defined in North Carolina General Statute 113-44-9. That, I believe, is a change from the previous situation. It used to be you weren't allowed concealed carry weapons in state parks. That has been relaxed now, and you are allowed to carry them. Note, weapons may be secured in vehicles on state property, so that's similar to the situation with the schools. A person with a permit issued in accordance with Article 54B of this chapter, or considered valid under North Carolina General Statute 14-415.24, who has a firearm in a closed compartment or container within the person's locked vehicle, or in a locked container securely affixed to the person's vehicle, i.e. a truck. A person may unlock the vehicle to enter or exit the vehicle, provided the firearm remains in the closed compartment at all times and the vehicle is locked immediately following the entrance or exit. So that's just the same as a school. C, moving on. Pursuant to North Carolina General Statute 106-503.2, the Commissioner of Agriculture is authorised to prohibit the carrying of firearms into the state fairgrounds during the state fair. Permittees may, however, secure the vehicle or secure the weapon in their vehicle in the parking lot. Individuals that are listed in North Carolina General Statute 14-269 brackets B, brackets 1 to 2, 3, 4, 5, may carry on these grounds during the state fair, and I think if you go into the weeds on that, you'll find that's police officers, armed security, and a few other exceptions, but not civilian concealed carry personnel. D, picket lines, demonstrations at private healthcare facilities, North Carolina General Statute 14-277.2. North Carolina law further makes it unlawful for any person participating in, affiliated with, or present as a spectator at any picket line or demonstration upon any private healthcare facility to willfully or intentionally possess or have immediate access to any dangerous weapon, regardless of whether they possess a concealed carry handgun permit. So basically, if you think of this in terms of an abortion clinic, where protesters turn up to protest the abortion clinic, you are not allowed to bring your concealed carry handgun to that. Or, by the same token, if you're at a Black Lives Matter protest or any other organisation, if you're taking part in the protest, you are not allowed to bring your gun with you. So, picket lines, demonstrations in private healthcare facilities. Perhaps the Black Lives Matter one's going too far on that. Just going back and rereading that, because it's specifically demonstrations at private healthcare facilities. I would suggest, however, that any of those other protests, it may be unwise to be armed at a situation like that, just because of potential friction with law enforcement. But that's one for another day. E, areas of emergency and riot. Pursuant to the North Carolina Emergency Management Act, North Carolina General Statute 166A-19.31 brackets B, brackets 4, local governments may impose restrictions on dangerous weapons such as explosives, incendiary devices, and radioactive materials and devices when a state of emergency is declared, but may not impose restrictions on lawfully possessed firearms or ammunition. So, North Carolina, I don't know if you remember the time of Hurricane Katrina in Louisiana and New Orleans. The police went round and rounded up a lot of personally owned firearms, which effectively left householders with no means of defending themselves. And some people got into conflict with the police over that. Some people never got their guns back. There was quite a lot of controversy about that. Well, North Carolina has specifically made it state law that during times and in areas of emergency and riot, the state may not impose restrictions on lawfully possessed firearms or ammunition. So when someone comes and tells you to hand over your guns and ammunition, that's contrary to state law. Just an interesting little difference there. Moving on. F. Any federal property, including building land, as prohibited by 18 U.S.C. 922 or any other federal law. For detailed information on this federal law, persons are urged to contact the Bureau of Alcohol, Tobacco and Firearms or the local U.S. Attorney's Office. Note, concealed handguns are allowed in federal parks in states in which the concealed carry permit is recognised. So the federal property, that could get really wide in terms of state parks, or not state parks, national parks, federal land, but you're allowed to carry your gun if you have a concealed carry permit on federal land in those states that allow it. And I believe North Carolina does allow it. However, they're not going to welcome you at your local FBI office or Bureau of Alcohol, Tobacco and Firearms. Those federal buildings, they do not want you carrying your gun in, and probably you will find them to be posted to that effect. G. On any private premises where notice that carrying a concealed handgun is prohibited by the posting of a conspicuous notice or statement by the person in legal possession or control of the premises. That's North Carolina General Statute 14-415.11. Now, where does this come in? The streets of South Point Mall have in the rules of the mall that you're not supposed to bring any firearms or weapons into the mall. But there are a number of entrances where you can enter the mall where that is not clear from how it is posted on the door. So your coverage there is conspicuous notice or statement. If you entered the mall through Macy's or Belk or one of those other store doors and you did not see a conspicuous notice telling you that you should not be there with your concealed carry handgun, that's fine. If you're concealing it properly, nobody's going to know you have it anyway. But if you're approached by public safety that someone has noticed that you are carrying a firearm, and public safety says, excuse me, the rules of the mall do not allow you to carry your handgun in the mall, then you're obliged, having had it brought to your notice, you're obliged to either go back and leave it in a locked compartment in your car, or leave the premises and take your business elsewhere as you see fit. So these are the real life areas where you may encounter some of these issues. H. Any law enforcement or correctional facility to include state, county, municipality, university police, or company police. Now bear in mind, these are all the places you're not allowed to take your concealed carry handgun. They don't want you walking into the police station with it. That's what the law is in North Carolina. I. In an office of the state or federal government that is not located in a building exclusively occupied by the state or federal government. North Carolina General Statute 14-415.11. So if there was a government office in a shopping mall or a strip mall, they still don't want you taking your concealed carry handgun into that government office. Basically, they want those kept as gun-free zones, except for law enforcement or whoever's there. J. Anywhere while consuming alcohol or at any time while any alcohol or any controlled substance is in the blood. North Carolina General Statute 14-415.11, including improper use of prescription drugs. So you should not be in possession of your concealed carry handgun if you are impaired by alcohol or recreational drugs or even prescription drugs. If you're on Klonopins or Oxycontin or some of those other drugs and it is impairing your faculties, they do not want you carrying a concealed carry handgun, and you can be prosecuted if you're found in that condition. Now we move on to number 8. We're on page 15, in case you lost your place. Statewide uniformity. North Carolina General Statute 14-415.23. It is the intent of the General Assembly to prescribe a uniform system for the regulation of legally carrying a concealed handgun. To ensure uniformity, no political subdivisions, boards or agencies of the state, nor any county, city, municipality, municipal corporation, town, township, village, nor any department or agency thereof may enact ordinances, rules or regulations concerning legally carrying a concealed handgun. A unit of local government may adopt an ordinance to permit the posting of a prohibition against carrying a concealed handgun in accordance with General Statute 14-415.11(c) on local government buildings and their appurtenant premises. A unit of local government may adopt an ordinance to prohibit by posting the carrying of a concealed handgun on municipal and county recreational facilities that are specifically identified by the unit of local government. If a unit of local government adopts such an ordinance with regard to recreational facilities, then the concealed handgun permittee may nevertheless secure the handgun in a locked vehicle within the trunk, glove box or other enclosed compartment or area within or on the motor vehicle. For the purposes of this section, the term recreational facilities includes the following. A. An athletic field, including any appurtenant facilities such as restrooms, during an organised athletic event, if the field has been scheduled for use with the municipality or county office responsible for operation of the park or recreational area. B. A swimming pool, including any appurtenant facilities used for dressing, storage of personal items or other uses related to the swimming pool. C. A facility used for athletic events, including but not limited to a gymnasium. D. For the purposes of this section, the term recreational facilities does not include any greenway, designated biking or walking path, an area that is customarily used as a walkway or bike path, although not specifically designated for such use, open areas or fields where athletic events may occur, unless the area qualifies as an athletic field, as noted in A above, and any other area that is not specifically described in this section. That's a big chunk of information, but what does it come down to? Well, basically, there are only certain areas where you can be stopped from taking your concealed carry handgun, and basically, if they are posted for those occasions, it is impairing your general ability to run around with your concealed carry handgun on you. But there are these exceptions that local government are allowed to do. But my understanding of it is local government cannot turn around and say no concealed carry in Chapel Hill. They can't turn around and say no concealed carry in Durham. They can only regulate it at certain places, at certain times, as laid out in this section. And that's my understanding, that the General Assembly, in its latest draft of the firearms law, has made things just a little more user-friendly for concealed carry. Moving on, Section 9, page 16, obtaining a concealed carry permit. In order to obtain a permit, the citizen must apply to the Sheriff's Office within their county of residence. The applicant will sign a release of mental health records as part of the application process, and effective October the 1st, 2015, no entity can charge a fee for the release of those records. The Sheriff shall issue a permit to an applicant if the applicant qualifies under the following criteria, according to North Carolina General Statute 14-415.12. A. The applicant is a citizen of the United States or has been lawfully admitted for permanent residence as defined in 8 United States Code section 1101 brackets A brackets 20 and has been a resident of the state of North Carolina 30 days or longer immediately preceding the filing of the concealed carry application. Proof of citizenship should be brought to the Sheriff's Office. Just a little aside on that. I applied in Orange County. Orange County and some other counties are more restrictive than say Person County or some of the smaller, more rural counties. The requirement in Orange County at that time was you had to be resident in the county for a year before you could apply. And I was, so it wasn't really an issue. But state law is if you're here 30 days, you're allowed to apply and you should be issued. It's also a change that legal residents can get a concealed carry permit, because that was not the case until about 2 years ago when the law changed. Next requirement, B. The applicant is 21 years of age or older. So that is the legal age to buy a handgun, and it's the legal age for a concealed carry permit, logically. C. The applicant does not suffer from any physical or mental infirmity that prevents safe handling of a handgun. Now, we had an interesting situation where a customer came into the shop and she had no fingers on her left hand, and I didn't deal with the sale, one of my colleagues did, but I couldn't understand how she could possibly operate a semi-automatic pistol because she had no fingers to hold the slide with. So if you have a physical or mental infirmity that prevents the safe handling of a firearm, sheriff should not be giving you a concealed carry permit. That's pretty wide and it's pretty open to interpretation. D. The applicant has successfully completed a concealed carry handgun training course that has been approved by the North Carolina Criminal Justice Education and Training Standards Commission, and whose instructor is certified by the same commission as a concealed carry handgun instructor. The applicant must submit the original certificate issued from the course to the Sheriff's Office as part of the application process. That's why you're here. I am a state licensed instructor, and the original certificate that I give you, which has a serial number on it, is the only thing that is acceptable to the sheriff. So you can make and keep a copy, but don't try giving the sheriff the photocopy. He will not accept it. E, and we're still on page 16 here. The applicant is eligible to own or possess or receive a firearm under the provisions of state or federal law. It's common sense. F, the applicant is not under indictment or against whom a finding of probable cause exists for a felony. So if you're a felon or you've been reported, you're being investigated for a felony, you should not be getting a concealed carry permit. G, the applicant has not been adjudicated guilty of a felony, so no permits for felons according to North Carolina state law. H, the applicant is not a fugitive from justice. Well, maybe you haven't been caught yet. Maybe there's a warrant for your arrest. That's a disqualifier too. I, the applicant is not an unlawful user or addicted to marijuana, alcohol, or any depressant, stimulant, or narcotic drug, or any other controlled substance as defined in 21 US Code Section 802. So alcoholics, stoners, dipsos and junkies should not be getting a concealed carry permit. J, the applicant is not currently or has not been previously adjudicated by a court or administratively determined by a governmental agency whose decisions are subject to judicial review to be lacking mental capacity or mentally ill. Consultative services or outpatient treatment alone shall not disqualify an applicant. This one's worth going into a little bit. If somebody has recorded in a documentary way that you are lacking mental capacity or have a mental illness, that could be a disqualifier. But if you've had some depression, PTSD, been treated as an outpatient, that's not a disqualifier. That affects maybe 25% of the population at some point in their lives. So there's certain guidelines there, and if in doubt, the sheriff will probably refuse you, but there's no harm in trying, shall we say. Okay. The applicant has not been discharged from the armed forces under less than honourable conditions. Self-explanatory. L, the applicant has not been adjudicated guilty of or received a prayer for judgment continued or suspended sentence for offences constituting a misdemeanour under the following specific statutes or any other crime of violence. Now, I'm going to whiz through these a little. They're on page 17, so if you can follow me and try and keep up, but you'll see that you can be denied a concealed carry permit for a misdemeanour if it's one of these misdemeanours. So let's go through them. 1, assault on handicapped person. 2, simple assault within 3 years prior to the date of the application. 3, assault inflicting serious injury or using a deadly weapon. 4, assault on a female under that statute. 5, assault on a child under the age of 12 under that statute. 6, assault inflicting serious injury or using a deadly weapon on a person in a personal relationship and in the presence of a minor. So that's basically domestic violence. 7, assault by pointing a gun, and that's an offence to bear in mind. If you bring out your gun and point it at someone and you don't have really good justification, that constitutes an assault, and that's worth knowing about. 8, the manufacture, sale, purchase or possession of Teflon coated bullets. I've never seen any, but if you do come across them, stay away. 9, criminal use of a laser device. I would imagine that one, there's very few prosecutions for that, but if you're the sort of asshole that tries to make a commercial plane crash by blinding the pilot with a laser, I'd imagine that's the kind of offence they're talking about, or drivers or police officers or whatever, you know. 10, domestic criminal trespass. 11, violation of court orders within 3 years prior to the date of application. And again, I would imagine these, we're talking domestic violence, harassment, those kind of things. 12, furnishing poison, controlled substances, deadly weapons, cartridges, ammunition, or alcoholic beverages to inmates of a charitable, mental, or penal institutions or local confinement facilities within 3 years prior to the date on the application. 13, Carrying weapons on campus or other educational property within 3 years prior to the date on the application. 14. And we're now on to page 18 of the book. Carrying weapons into assemblies and establishments where alcoholic beverages are sold and or consumed within 3 years prior to the date on the application. 15. Carrying weapons on state property and courthouses within 3 years prior to the date on the application. 16. Possession and or sale of spring-loaded projectile knives within 3 years prior to the date on the application. 17. Impersonation of a law enforcement or other public officer within 3 years prior to the date on the application. 18. Communicating threats within 3 years prior to the date on the application. 19. Carrying weapons at parades or other public gatherings within 3 years prior to the date on the application. 20. Stalking. 21. Exploding dynamite cartridges and or bombs, except for a violation involving fireworks, within 3 years prior to the date on the application. 22. Rioting and inciting to riot within 3 years prior to the date on the application. 23. Fighting or conduct creating the threat of imminent fighting or other violence within 3 years prior to the date on the application. 24. Looting and trespassing during an emergency within 3 years prior to the date on the application. 25. Assault on emergency personnel within 3 years prior to the date on the application. 26. Violations of state of emergency ordinances within 3 years prior to the date on the application. 27. Violations of county state of emergency ordinances within 3 years prior to the date on the application. 28. Violations of state of emergency ordinances within 3 years prior to the date on the application. That seems to be in, it's city, county and state. Right, boom, 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 that's 3. 29. Child abuse. Leaving your child in a car in the hot sun or something, or whatever other form of child abuse, I guess. 30. Violations of the standards for carrying a concealed weapon within 3 years prior to the date on the application. And bear in mind, being a concealed carry permit holder is a big responsibility. Quite a lot is expected from you. Typically they are the most law-abiding citizens you could ever meet. But if you fall foul of those standards and maybe the sheriff decides to revoke your permit, that's something they're going to hold against you for the next 3 years at least. 31. Misrepresentation on certification of qualified retired law enforcement officers. So if you lie about your qualifications and you're prosecuted for that, you represent yourself to be a retired cop or whatever, that's different. 32. Domestic violence protective order violations. So if you breach a protection order. 33. Has been adjudicated guilty or received a prayer for judgment, continued or a suspended sentence for crimes involving an assault or a threat to assault a law enforcement officer, probation or parole officer. Person employed by the state or local detention facility, firefighter, emergency medical technician, medical responder, or emergency department personnel. So do not punch your paramedic. It could go badly for you. 34. Any person convicted of misdemeanor crime of domestic violence as defined in federal law at 18 US Code 922. So that's a list of 34 different misdemeanors that can disqualify you from getting a concealed carry permit. Moving on, we're now on page 19. M. The person is not free on bond or personal recognizance pending trial, appeal or sentencing for a crime which would disqualify him or her from obtaining a concealed handgun permit. So if you haven't been convicted yet of any of these disqualifying offences, but you're waiting to go to court, you shouldn't be applying, basically. The applicant has not been convicted of an impaired driving offence under any of the following general statutes within 3 years prior to the date on which the application is submitted. And that's impaired driving in commercial vehicle, driving by a person less than 21 years old after consuming alcohol or drugs. So basically, if you have committed any of those offences, they'll forgive you after 3 years, but not until then. Oh, domestic violence issues, and that's the letter of it. A court in any domestic violence protective order can prohibit a party from possessing, purchasing, or receiving a firearm for a time fixed in the order. Further, effective September 30th, 1996, 18 U.S. Code 921A was modified in the Lautenberg Amendment to prohibit the possession of firearms and ammunition by anyone convicted of a misdemeanor under federal or state law which has as an element the use or attempted use of physical force or the threatened use of a deadly weapon committed by a current or former spouse, parent or guardian of the victim, by a person with whom the victim shares a child in common, by a person who is cohabiting with or has cohabited with the victim as a spouse, parent or guardian, or by a person similarly situated to a spouse, parent or guardian of the victim. So I would say basically if you've any sort of domestic violence issues going on there, you're probably not going to get a permit. 10. Reciprocity. North Carolina law allows residents of other states who have a concealed carry handgun permit issued by their state to carry concealed handguns in Northern Ireland. For North Carolina permittees who wish to carry in another state, you may obtain a current list of those states that honour the North Carolina permit by visiting the North Carolina Department of Justice website at www.ncdoj.gov. Under the Crime and Law Enforcement section, a drop-down menu will appear. Click on Law Enforcement Training and Standards, click on Law Enforcement Liaison, and then click on Concealed Handguns Reciprocity. This will direct you to the latest information on those states that allow North Carolinians to carry concealed. Remember that while travelling in other states, you are subject to the laws of that state, so please be aware that the use of deadly force laws may be different, as well as those places where carrying concealed is prohibited. Consider contacting the Attorney General's office of the state in which you will be travelling for the current laws of that state. So yes, you're learning North Carolina law, but if you go to Virginia or South Carolina, you may find there are some significant changes, not to mention the other 49 states that you could wind up in. 11. Course requirements. Now here's the meat and bones of what you'll be doing with me over the next 6 hours, because the first 2 is about done now. The concealed carry course that an individual attends must meet several minimum standards as set forth by the North Carolina Administrative Code. Those requirements include: course must be a minimum of 8 hours long, plus the range qualification time. The legal block of instruction must be a minimum of 2 hours in length. Now we can do this over 4 days, or 2 days, or any combination of that, but on any one day you must be doing at least 2 hours of instruction. A written legal examination is required. You will be doing that soon after this presentation, if I have planned things right. A shooting proficiency examination is required. The course of fire must be a minimum of 30 rounds, with 10 yards fired from the 3-yard line, 10 yards fired from the 5-yard line, and 10 rounds fired from the 7-yard line. That's the absolute minimum. We probably will fire more than that. The concealed carry course must cover the following topics, or it does not meet the minimum state standards. Those topics are: 1. Legal issues. 2. Handgun safety. 3. Handguns. 4. Ammunition. 5. Marksmanship fundamentals. 6. carrying concealed safety issues. 7, presentation techniques. 8, cleaning and maintenance. 9, proficiency drills. Perfect time.